Okay. Okay, morning everybody. I see that we already have about 45 participants who have joined. I'm going to suggest that we allow, it's 2 minutes past 10 on by my clock. I'm going to suggest that we just wait for a further 3 minutes or so to see how many other people join. And then I think we can kick off. I see that there already is a question on the chat saying, will the recording be made available? Yes, the recording will be made available, and I think that Reena will, speak to that towards the end of the session. Can I also, I'll probably have to repeat this, but can I suggest that I'm going to be keeping a much closer eye on the Q&A than I am on the chat. And so I'd like to encourage people to rather use the Q&A if they have a question that they want to pose, rather than the chat function. Okay, I think just gonna wait for 1 more minute, and then we will proceed. I see we already have a lot of participants who have joined the call, joined the webinar. Okay, I think let's kick off. Thank you everybody for joining this virtual event. I'm very pleased to see that there is a very strong interest in this webinar on price discrimination and buyer power guidelines. By way of introduction, by way of background, this is a joint initiative between the Department of Trade, Industry and Competition, and specifically the unit that I am responsible, the Industrial Development Advisory Unit, which organizes, together with partners, capacity building workshops such as this. We're also very fortunate to have to be partnered by the Competition Commission and the Center for Competition Regulation and Economic Development at the University of Johannesburg. The objective of this webinar is to help the participants better understand the implications of the price discrimination and buyer power guidelines, which have fairly recently been released by the Competition Commission. And I think in particular, what we want to touch on today are the implications of these guidelines for suppliers, for medium and small suppliers, as well as Black-owned suppliers into the retail chain particularly into the supermarket retail chain. And this is also in the context of a process underway to formulate an agriculture and agro-processing master plan, which is being led by the Department of Agriculture, Land Reform and Rural Development, and supported by the Department of Trade, Industry and Competition. I think that the presenters, perhaps particularly James, will also touch on the fact that these guidelines also have implications in the digital space for certain online platforms. So let me quickly introduce the speakers, and then I think we can kick off. So we're going to start off with Dr. Reena Das Nair. She is a senior researcher at CRED, and she was formerly a principal economist at the Competition Commission. She has extensive experience in researching barriers to entry in food systems, particularly barriers to the participation of small and medium enterprises. And I think that she is going to focus on contextualizing the price discrimination and Bypower guidelines, the implications, for instance, for the suppliers to supermarkets, to the supermarket chains. And then we also have James Hodge, who is the Chief Economist of the Competition Commission, and also has very extensive experience in competition matters and regulation with respect to specific sectors. And I think that James is going to just help us understand the core of the price discrimination and Bypower guidelines. After that, we'll open up for questions and answers. As I indicated earlier, please can you use the question and answer tab, which you should be able to see at the bottom of your Zoom screen, rather than the chat tab. And that will help me direct questions to the appropriate respondent, the appropriate panelist. What I'd also like to do is, just to allow the flow of the presentations to proceed fairly uninterrupted, let's take questions and answers at the end of the presentations. I find that often what happens is questions that are raised during presentations actually may often be addressed during the rest of the presentation. So I think if we just kind of follow those kind of house rules, if you like. So with that introduction, sorry, the only person I didn't introduce is myself. My name is Nimrod Zalk. I'm Industrial Development Advisor in the Office of the Director General of the Department of Trade, Industry and Competition, and I'm moderating the session. So let me then hand over to Dr. Reena Das Nair, and then she will be followed by James Hodge. Thank you.
Thanks very much, Nimrod, and thank you to the DTIC for the invitation to participate in this webinar. As Nimrod has mentioned, this webinar is very timely given that the Department of Agriculture, Land Reform and Rural Development, as well as the DTIC, are involved in the development of the Agriculture and Agro-Processing Master Plan. A vision of this master plan includes creating globally competitive agricultural and agro-processing sectors, and this requires the meaningful participation by all players and stakeholders in food value chains, whether they're small, medium-sized or large enterprises. Another key objective of the master plan, which is relevant for the session, is that it aims to build industrial capacity and capabilities, and as well as unlock significant opportunities for the South African farming and agro-processing sector, again, particularly particularly for small and medium-sized enterprises and Black-owned enterprises. And this is all part of a bigger vision of creating more inclusive food systems. The success of this master plan is based on a very close partnership between government, the private sector and industry, labor and civil society organizations. So if you like, a social compact is needed to achieve some of the outcomes and objectives of this master plan. So this webinar is particularly significant for the goals and objectives of this master plan, because anti-competitive conduct by players along food value chains at different levels of food value chains in the form of price discrimination and abuse of buyer power that we're discussing in depth today can really create barriers to entry for these players, and it can stand in the way of SMEs from achieving these outcomes of more inclusive participation in these value chains. As part of the research that we've been doing for this master plan, we also recognize the very powerful part that large businesses, such as your supermarket chains and large agro-processors, play in building the capacity and capabilities of their suppliers. And we've been looking at the enterprise development programs and the supplier development programs that these players engage in to build the skills, the capabilities of particularly SME suppliers along the value chain. And all of the main supermarkets chains in South Africa and some of the large agro-processors have really fantastic enterprise development programs and supplier development programs, and they've supported SMEs in many different ways. For instance, through loans, through technical assistance, in building production and other capabilities, marketing, ensuring that they have guaranteed offtake commitments, as well as various terms and conditions that are, you can say, relaxed for these players or these suppliers that are part of their supplier development programs. The big agro-processors, such as your sort of Coca-Cola, your AB InBev, Tiger Brands, also have quite substantial supply development programs. So the master plan research has identified that there are opportunities to expand on these supply development programs in order to meet the objectives of more inclusive participation of SMEs. There are various opportunities to expand the scope of these supply development programs. For instance, ensuring that there are good labor practices in the value chains that are part of these programs, as well as ensuring sustainable environmental practices. So all of this is in the spirit of creating more inclusive food value chains. And of course, this also involves or needs complementary support from governments, skills development organizations, development finance institutions to help SMEs build their capabilities and supply within these value chains. So the new provisions that we're discussing today, those of price discrimination and buyer power, are very much in the spirit of enabling greater participation of SMEs and inclusion in food value chains, and are really highly complementary to the objectives of the master plan. So I think you know, when James discusses these provisions, it'll be quite clear to see how well they fit in with the bigger vision of this master plan. So just to talk very briefly about each of these provisions, but you know, James will do a much better job at this, but again, just to try and situate it within the master plan and the importance of it within the master plan. The Bypower Provision in particular, which was promulgated in 2020, under this provision, it is prohibited for a dominant firm as a buyer in designated sectors to either require or impose unfair prices or trading conditions on small and medium-sized businesses or firms controlled or owned by historically disadvantaged persons. So this usually applies to your very large buyers who exert or who yield significant power when it comes to negotiating prices or supply conditions with SMEs. So as you can imagine, this is directly related to some of the things we're looking at in the master plan. James will, of course, provide more detail on which category of SMEs this would apply to. This provision applies to certain designated sectors, and the sectors which are designated are your agro-processing, your grocery, wholesale, and retail, and as Nimrod mentioned, the e-commerce and online services as well. The Commission, as part of its grocery retail market inquiry, also made recommendations around the concerns that they had around the buyer power of large players along food systems. And these concerns have also led to this amendment to the Competition Act and subsequently the buyer power provisions. Just to talk very briefly about what the second provision we're looking at today, which is the price discrimination provision. Under this provision, the action by a dominant firm as the seller of the good or service is prohibited price discrimination if it has the effect of impeding the ability of small and medium-sized businesses or firms controlled or owned by historically disadvantaged persons to participate effectively. So while the buyer power provisions is around the ability of buyers to exert power in a way that harms SMEs, on the price discrimination side, it's the ability of the seller to have an effect on impeding the ability of SMEs to participate. So this seminar, it becomes very important to both large players in food value chains as well as SMEs, because large players also need to be clear about what conduct may fall foul of these new provisions. From the SME perspective, they also need to be capacitated on what conduct they might face as being a player in food systems. And importantly, what recourse they have if they find themselves in this position where they're facing buyer power from the buyer side or facing some sort of price discrimination from the seller side in terms of the inputs that they use in production. And further, as the master plan process progresses and as the Department of Agriculture, Land Reform and Rural Development and the Department of Trade, Industry and Competition continue to embark on negotiations as part of the master plan process with your large players like supermarkets and large agro-processors, there are some proposals that we'd like to develop. So for instance, like I mentioned earlier, expanding supermarket supply development programs. And it would be important as part of this process also to get a better understanding of what kind of screening that the Competition Commission will do when they're looking at cases of abuse of buyer power and price discrimination cases, and the kind of tests that they'll undertake to sort of establish whether there's a violation of these provisions. James will of course explain in more detail what constitutes each of these, an abuse or an offense under each of these provisions, but just to sort of introduce the idea, under the buyer power provision, for instance, certain behavior like delayed payments, so payments from a buyer beyond 30 days or much further beyond that might be considered problematic. There may be concerns about cancelling orders, unilaterally cancelling orders of perishable products under short notice, or imposing trade conditions without sort of equal negotiation in these discussions, or charging unrelated fees in order to stock products, SMEs to stock their products on supermarket shelves. There are various others that the guidelines, I think, quite nicely and in quite a lot of detail set out, which might be problematic. But I'm sure James will talk about this as well as examples of where this might be a problem. This session is also very important to understand, as I said earlier, the tests that the Commission will use to screen for whether a price is unfair or a trading term is unfair. And one of the tests or benchmarks that is noted in the guidelines that we circulated as part of this, as part of the invitation, is that prices or terms and conditions will be compared to another group of sellers or buyers outside a designated class. So for example, what are the prices or the terms and conditions that the SME is facing versus perhaps a larger supplier into the value chain? And that could be one of the tests that is considered, and James can speak a little bit more about this. It would then be useful to know if there's then a chance that the large retailers or agro-processors might get into trouble if the supplies they have under their supply development programs are treated in a different way to other SMEs that are not part of supply development programs, if that indeed would be a test, one of the tests that's employed to see whether there is price discrimination or, in this case, excuse me, abuse of buyer power. So that would be something I'd be interested to chat to James about. The guidelines, I think, also provide some really good information about supply development and enterprise development programs more generally, around how it's very unlikely that small players that are part of supplier development programs or the design of the program would fall foul of these provisions. And this is something that James can also talk a little bit more about. So I think maybe just to conclude there and to take questions later around the link between these provisions in the master plan, I'd just like to reiterate that these new provisions of biopower and the price discrimination provisions very much line up with the goals and objectives of the agriculture and agro-processing master plan, which includes creating, as I said, more inclusive food value chains and food systems with much greater participation of SMEs and historically disadvantaged firms. So with that, I'd like to hand over to James to give you a bit more detail on the provisions and some of the tests that are employed in the screening and investigation of these cases, as well as some examples that the Commission has been working on. Over to you, James.
Thank you, Reena, and thank you for an opportunity to set out these guidelines to the industry. I think as has been set in terms of context, our focus today is really on the food value chain and the master plan and where these fit in. I think there's a recognition that better SME participation, also more spread of ownership in that value chain, has a lot of benefits and brings a lot of vibrancy, whether it's new products, whether it's just an opportunity to participate in the value chain. Work the Commission has been doing, which we'll release soon, on concentration and participation across the economy, in fact, shows that in agriculture and agro-processing, there's been quite an alarming reduction in number of farmers, growth in the size of the farmers, but also high levels of concentration, lack of participation at upstream inputs and also the processing side. I think what we've identified, and which is almost the root of these amendments, is that small businesses, medium businesses, as well as new entrants, historically disadvantaged businesses, almost face additional obstacles in order to compete. So the playing field is not level. So in this context, they often pay more for inputs, and that may be behind, for instance, some of the reduction in farmers who aren't able to get to scale and get the better prices for their inputs. But they also often paid less for their outputs, or they face trading terms that really are unfair in terms of imposing either additional costs or just exposing those businesses to risk. So that's why the two combined. Price discrimination deals with the inputs supplied to these businesses, and biopower deals with the sale of those outputs from the businesses. The point of putting up regulations and guidelines, even though there isn't historical case precedent, is really in order to provide much clarity to businesses as to how the Commission will approach enforcement. And as Reena indicated, also I think to empower small businesses, historically disadvantaged businesses, in their negotiations, discussions on a daily basis, either with input suppliers or with buyers of their products. We can't possibly engage in all those interactions that happen on a daily basis. And so this provides at least a guidance. And we have seen it being used already in a number of areas in agro-processing. For instance, we do know that in dairy, they've been used extensively, and I'll come to some examples there too. Maybe just to set out a few core features of both price discrimination and biopower regulations and guidelines and how they're applied. So the first is they do apply to dominant firms, either dominant buyer or dominant seller. And the Act does put in a prescription around market shares, but importantly, it also says that where the conduct reveals that the firm has market power, so either a buyer that just unilaterally imposes, for instance, conditions on many of the sellers to it, then there can be a finding of market power. And importantly, a recent case before the appeal court established exactly that precedent, that we can look at conduct in order to understand market power. So I think it's important not to take too much comfort from delineating markets and assessing share of markets, either as a buyer or a seller, and more to focus on conduct and engagement with buyers and sellers of products to you. I'll come to an example, but during COVID, we identified a number of times there where firms just unilaterally changed their terms of contracting with those suppliers that were small, and that itself reveals that there may be a degree of buyer power. So a lot of the guidelines focus also on conduct dependency, the lack of alternatives in terms of buyer side. I think the second thing to note is that the focus of these provisions is on harm to small businesses or historically disadvantaged businesses. It's not a focus on whether consumers are better off or not. And that's an important aspect. So, for instance, squeezing your suppliers and then passing on that saving on to consumers is not something that's going to be weighed up in the round when we look at buyer power, for instance. So what matters is how it affects these participants. And why that's important is also because what we're trying to establish through these provisions is the basic ground rules for fair and level playing field for small businesses and historically disadvantaged. As I indicated before, it's often that the level field is not in fact level and they face additional obstacles. So it's removing those obstacles. It doesn't mean, as we put out in our frequently asked questions section, it doesn't mean that they need to receive preferential treatment. They just shouldn't receive discriminatory treatment. I think a third aspect that is important to bear in mind is there is a lower level of materiality threshold in terms of the harm. So in the buyer power test, it's simply whether for instance, the trading condition is unfair. That may be a trading condition around taking back perishable products that became waste. It may not have a substantial effect on the financials of the firm. It's a focus on unfairness purely. In the price discrimination test, it's not your typical substantial lessening of competition. That is a separate provision in price discrimination. Here, the test is really about, does the differential in price impede the ability to participate effectively? And I'll come to what we understand by that. But it is just an impede test, not a substantiality test. As Reena's already touched on, another important point is buyer power is limited to designated sectors, and that includes the food value chain, agro-processing through to grocery, wholesale, and retail. It also includes online intermediation services, but I won't focus on that much today, given the target audience. In terms of its application to SMEs, SMEs are defined in terms of the Small Business Development Act and is attached to the regulations. But to give you an idea, medium businesses, so that's the upper threshold, typically are identified by a maximum employment of 250 people. The turnover differs by sector, but in terms of agriculture, that turnover is 35 million or less. In terms of retail, it's 80 million or less, and wholesale is 220 million or less. So that gives some idea of which firms might fall within that net. In terms of historically disadvantaged, it is firms that are owned and controlled by historically disadvantaged persons. And there, the threshold just sets a 20% share of either your sales in a price discrimination context or your purchases in a buyer power context. So one can establish, obviously, much larger firms that are historically disadvantaged, but not SMEs, and that's the point of inclusion. A further element is there are avoidance provisions in these laws, which means if you decide to avoid having to deal with providing fairer treatment or equal terms in terms of sales by not dealing with SMEs or historically disadvantaged firms, then you can be prosecuted on that front. Now, this doesn't create an obligation to deal, but certainly if firms show behavior where they're effectively refusing to deal, then the avoidance provisions would kick in. This is obviously, in a price discrimination context, I think an easier thing to identify because no firm really wishes not to sell more of its products to other buyers. In a buyer context, one obviously has to understand whether there are reasons for not purchasing or not. In terms of the last 2 points, the other aspect that it raises is whether this needs to be discrimination or unfair treatment of the entire group or just an individual firm. And certainly the approach in the law and from the Commission is that it can be an individual firm. There's not the desire to bring some group claim of unfair treatment and to organize a group. Often that single firm will reflect a broader pattern of behavior in any event. And lastly, there is what is called a reverse onus. So once the conduct has been established, it's going to be up to the firm, either the buyer or the seller, to justify the difference in behavior. So why this is, I think, particularly important was highlighted again by this recent appeal court decision on price gouging, where in fact, once one gets to that stage, if there is no reasonable justification, then a prima facie case has been established and one can prosecute. What is also important in that is it's not just whether a reason exists, it's whether that reason can account for the extent of the difference. So in a price discrimination context, if there is a reason, say, based on logistics costs for a difference in the price charged, it can't be a free ride to charge any difference in price. It must be related to that. And I think if I had to take one thing away, or ask firms that may be subject to this law, one thing away from this is you need to start to understand where the differences in what you pay, how you treat firms, or differences in your selling price are actually justifiable and reasonably linked to objective facts and costs. Because if that is the case, then you should be relatively safe within the broader context of prosecution. But if it's not the case, then you risk a finding of unreasonableness. Looking at buyer power, I'll quickly deal with unfair price and then trading conditions. Unfair price has been the subject of quite a lot of debate, and through the submissions we received and the process of developing the regulations and the guidelines, there was a lot of concern that in effect either an unfair price finding could be made without the firm actually having done anything in terms of paying for that price, or where it's based on knowledge they don't have, such as the costs of the supplier and whether they're profitable or not. So what the guidelines and the regulations have sought to do is to narrow the scope to areas where it's clearly within the actions of the buyer. So it's a conscious act in order to pay a different price or reduce prices, and where it is also within their knowledge that the kind of impact that this may have. So there's two categories we've looked at. The one is an unjustifiably lower price compared to other like suppliers. And then the second is an unjustified reduction in prices or imposition of costs, because in effect the net price can either be because you reduce the price or you add additional costs. And I'll come to examples in both of these. But if we start with the lower comparative cost, what we need to obviously look at is net price. So we will be looking at whether there's rebates, discounts, etc. So getting to a net price for comparative purposes is important. And then it's comparing the price paid to either a small firm or historically disadvantaged firm compared to suppliers of like products. And I say it's like products, it doesn't have to be identical. It should just be intrinsically or extrinsically similar. And our concern primarily is about sizable, persistent differences in price. So it may be that more temporary ones will raise less concern. The size will obviously raise concern. And for screening purposes, we're using a 3% difference in price. And also if there's a consistent discrimination against particular class of firms that we're looking to protect here. But to give you some examples to maybe help bring this alive, in the intermediate context, and especially in agriculture, often like grade or quality or goods are almost defined, that you've got grades, for instance, for potatoes, for tomatoes, for grains. And so the likeness can easily be established through that process. Also, if it serves the same purpose in production by a processor. So it may be that again, you know, dairy products, one may differentiate based on butterfat content, but once after adjustments for that, it serves the same purpose in the processing. So we can look at likeness in terms of those contexts, either grades that are set in agricultural markets or the purpose it's used for. In the resale context, often we'll have brands and brand differences and quality differences in terms of processing. So that can become a little more tricky in terms of assessing likeness. But again, I think what one can do is look quite clearly at the margins earned, the gross margins earned by the retailers or wholesalers. So if, for instance, products are bought at different prices but are resold at the same price and high margins are made on the small business product, then that might be indicative, certainly, that there is discriminatory buying practices and abuse of buyer power in that. Again, once we've established these differences, then the onus does shift, and the justifications must be linked to real costs or risks that come up in a contractual basis. So it might be payment terms differ, it might be service levels differ, it might be the extent of commitment over time, long-term contracts versus short-term. It might be logistic costs of fetching the product from a farmer, for instance. But one has to link it, and importantly, the extent of difference must reflect the extent of price difference. So it is, again, going back to that takeaway that firms, either processors or retailers that may have buyer power, and those are probably the main categories in the food value chain, they need to start to think about what justifies the difference in treatment that they have. And that is designed to protect small businesses that lack any countervailing power and may be exploited in the process. In terms of an unjustified reduction in price or imposition of a cost, here we're more likely to find a problem if it's a unilateral one and not subject to any form of discussion or negotiation. Obviously, sham negotiations or discussions would be excluded too. If it's retrospective, in other words, applying to sales that have already taken place, and then, of course, if it lacks any objective justification and is therefore unreasonable. And importantly here, that we are aware, for instance, in dairy, that there are contractual terms that typically look at adjustments in price if there are material market changes. That doesn't protect one from this sort of finding. The mere fact it's in a contract, assessment will still be on reasonableness. But let me give you some real examples which we encountered in the past year since passing the guidelines as well as the regulations. So obviously COVID created some market disruptions. But we had a few examples where dairy farmers came to us in terms of the Bypower provisions, and we acted successfully. So the one was where on the, I think the 29th of March, a dairy processor sent a letter to all its dairy farmers saying, as of the next day, there will be a 45-cent levy imposed on all purchases from farmers. So that would effectively reduce their price by 45 cents because they'd have to pay the levy. And it cited the COVID context. Now, we did act immediately. And I suppose the context from the Commission is, first, it was a unilateral one. Even contractually, any adjustments in price needed a month's notice. This was unilateral at a day's notice. Secondly, there was no justification for the 45-cent levy. It was speculation from the dairy processor themselves. And after engagement with them, in fact, they did negotiate or discuss with farmers. There was examination of a potential levy of half the amount, but in fact, no levy was ever imposed in the end. Now, this is a good example of unilateral action, no negotiation, imposing that on the farmers, and obviously it's a reduction in price or increase in cost that occurred. Another example is a few other dairy processors then also unilaterally announced that they would no longer pay winter premiums in the dairy sector, which is often used to purchase feed in the winter period and boost production. Again, unilateral, again, demonstrating exercise of market power, but also without any justification for its removal. And in fact, again, after engagement from the Commission, both these dairy processors resumed paying the winter premium. Now that highlights, I think those examples highlight nicely the sort of reduction in price and how we may look at it contextually. But it also highlights, that even where a processor or grocer faces some disruption even in their market, that's not a reason to move all of the risks and costs of that disruption downstream to your suppliers. That's where, if there is a fair balance of power, there's more a distribution of those risks and costs between them. And so the mere fact, again, that there was a disruption was not enough to prevent the Commission acting and looking to prosecute if there wasn't a reversal of those decisions. It's the extent that needs to be justified. I think what it also highlights is again my point about dominance, that in narrower markets, especially in processing, where it's often a regional market or local market, where there is a dependency because products can't be distributed in long distances, there may be market power even among slightly smaller firms. And again, the CAC decision in the price gouging has confirmed that this can be the case. In terms of unfair trading terms, the general principles we're applying are ones which are almost well established in law around unfairness. So an unfair transfer or unreasonable transfer of risks or costs onto the supplier. And I highlight risks there as well, because risks may not always result in a cost, but they expose the business to potential costs. A second category is the condition is one-sided, onerous, or not proportionate to the objective. And that includes, for instance, unduly long payment terms. So to give you an example of an unfair or unreasonable transfer of risks, or, for instance, if the supplier to a grocer is made liable for any wastage when, in fact, after transferring it to the grocer, that's beyond their control. The control of the grocer is to forecast demand and determine whether, they've got their forecast right, and hence to eliminate or minimize the wastage from perishable products. To impose that risk on the supplier when they have no control over that is an unreasonable transfer. The one-sidedness or onerous, again, may be unduly long payment terms. So in fact, the guidelines stipulate a 30-day payment term and anything above that would be considered unfair. But that is unduly onerous, especially given that most products, especially perishable, are done within a short period of time. But even non-perishable products, if again the grocer is inefficient and cannot predict its own demand, then it may encounter stock on shelves longer than 30 days. But that is really due to their own inefficiency rather than necessarily the supplier. And then lastly, the condition bears no reasonable relation to the object of the supply agreement. And this we've seen in the grocery context where, for instance, there are required payments from the supplier to either promote generally the grocer's products, but not the actual supplier's products alone, payments for stocking, etc., where they can't really be justified by the actual objective of the supply agreement. Now, as part of this webinar, we have, I think, released, or it's on the Commission's website, the exact sort of set of concerns, what we'll consider unfair. And there's probably two categories there. The first is ones that are per se unfair. So ones where, for instance, payment terms longer than 30 days, we will consider unfair. Payments for things that have no relation to the actual contract, again, would be deemed unfair. Retaliation against someone who lays a complaint would be unfair. So that's a category which is per se unfair. The second category is considered unfair if it's not contractually agreed beforehand and still must be quantified and must have some relationship to the cost. So if it's not related to the cost, which is not quantified and transparent, then in fact, it will still be deemed unfair. So to give an example, if there is some cost to the grocery for listing a product on its database, then that may be contractually agreed, but then the grocer needs to quantify what is the cost of listing that, and the price or cost that the supplier pays must be related to that. So it can't be an excuse for general charges that are made against the suppliers. So similarly, if there is a payment for promotion, then it needs to be contractually agreed so that the supplier is aware of it. But then the actual costs that they pay must be related to the exposure that they get. And it can't be that, again, it's just a charge that's levied. I won't go into the online intermediation ones, but those do have some bearing to regulations in Europe, and to highlight maybe also that the ones in the food chain are drawn from the European experience, and these are therefore have some standing globally in terms of a standard of unfairness. Let me quickly go to price discrimination, and then we can field some questions. Importantly, on price discrimination, the Commission hasn't finalised its guidelines. We anticipate that we will be able to release them relatively shortly. So I'll give you some flavour of some of the direction we're going, but I think a lot of the foundations around those guidelines and the regulations are established already. And so it's really about how we might look at different cases differently in a discrimination context. I think the first thing about price discrimination is it can get legally complex because there's a number of preconditions that need to be established in order to do a comparison. And I don't want to detain everyone with some of those legalities, but in essence, the first is that it's a sale in equivalent transactions for goods of like grade and quality. So the goods of like grade, much like I discussed in the biopower context, likeness is not identical. It's similar, and it may be that they have similar grades or quality measures that might be assessed. Equivalent transactions is really to differentiate where there may be reason for substantial difference in price due to the nature of the contract. And the typical example here is whether I have a contract, an ongoing long-term contract, or I'm doing spot purchases. So spot purchases might be priced differently because there's some benefit to a long-term contract for both the seller and the buyer in terms of that commitment. I think the second thing, maybe just to highlight in this, is that the Commission is also aware that sometimes, certain transactions are not made available to small businesses or historically disadvantaged firms. And if they're not made available, then that's a form of discrimination itself. So it's no defense to say, well, these are not equivalent, if in fact the small firm is not allowed to, take the example, buy on a contractual basis as opposed to a spot basis. If the small business is unable to take a delivered price versus an undelivered price. So equivalence still means that what we're trying to assess here is, and why it's carved out in terms of discrimination, is if that option is available to a firm and they elect not to take it, then they can't cry foul of discrimination. But if it's not made available in the first place, then that is a form of discrimination. I think the second element is price discrimination, because we're looking at hindering or impeding participation in a market. There is a sense of a market. And the prices compared will typically be firms in, and I'll use the word, broadly the same line of business as the SME or historically disadvantaged firm. And why I say that is that there can also be discrimination that prevents entry into certain lines of business precisely because of the difference in price. And one needs to enable them to capture those examples. It might be, for instance, that small firms are unable to succeed in government tenders because, in fact, the discrimination makes them uncompetitive in that context. So the mere fact they're not active there does not mean that there's no impact. And so I think firms that are big suppliers, and in the agro-processing world, that is probably your input suppliers to farmers and your processors who will also sell to smaller retailers. The third element is that it's a likelihood test. So there's no need to necessarily show the effects. Effects, if shown, are a positive. But one also needs to be able to act in context where, as I said, the price is likely to lead to impeding participation. So a likelihood test just means, on the balance of evidence, a reasonable inference is that it's likely. So if the price difference is so large, one may draw reasonable inferences, and that is often the court's approach, is one can draw legal valid inferences from facts and evidence. A fourth element is that any differences ultimately must be justifiable by differences in costs of supplying. And an important element to the price discrimination guidelines is volume is not a factor that can be used to justify the difference, even if that volume impacts on the costs of supplying. So there is a conscious effort from the legislature to rule out, in essence, volume discounts that continue to discriminate against small businesses and often new entrant, historically disadvantaged players into these markets. So that is an important takeaway, that if the sole basis for the difference in price is the difference in volume, or the difference in volume is driving the difference in costs, then that is not a reason to discriminate, and the Commission will prosecute those cases. So either your input suppliers or your processors in these value chains needs to start to look at their pricing and determine, what is the justification for the difference. If they're coming back to a volume-based element, then that needs to be eliminated. Again, we are, of course, going to be aware of sort of window dressing certain discounts, not as volume. And what we found out in the grocery retail market inquiry is there are many rebates out there that are offered to large chains, for instance, that really are volume discounts. They really bear no relationship to how they're notionally classified. So in dealing with rebates, the Commission will be looking at exactly whether that rebate is real, the benefit is real, and what are the actual cost savings. So firms in the supply chain need to start to look at their rebate structure and whether they're just supplying, a big additional discount to a big retailer under the guise of a rebate for something that's not really there, then that behavior again needs to change. If we look at the test of impeding effective participation, I mentioned earlier that this is not a substantiality test in terms of lessening competition. That part of price discrimination remains in the Act. There's a separate provision for price discrimination which causes a substantial lessening of competition. This is focused on the participation of small businesses or historically disadvantaged businesses in their lines of business. Participation is defined in the Act about sustaining a business, but impeding effective participation means more. So there has been a sense from some of the legal commentators that this may just require not exiting the market, being able to just survive in the market, and that's certainly not the view the Commission takes. And it's not the view that the regulations take either. So if we look at the regulations on this, they talk about whether differentials might result in reduced demand for the products, or whether it results in decreased profitability and decreased investment. So there's a very clear indication that this is not about whether these firms are able to survive, but rather whether they can thrive in this context. So if for instance, a difference in price may reduce the sales of a small firm, then that certainly would be concern to us. And I'll give you some examples. But the guidelines, the draft guidelines out there did put in a sort of threshold of 5%, saying we may, for screening purposes, not look at differences under 5%, but above that we will be interested and we'll look at that. And I think that threshold is likely to remain once we finalize these guidelines. So let me maybe take a look at the two contexts, and this is where the final guidelines will just need to segment. The factors listed, apart from whether it affects your demand or whether your profitability and investment, also includes the size of the difference, the importance of the input, and that's just not, it's important in the cost structure, but also important as a sales driver. So we all know in food retail, for instance, that certain products will be drawing feet through the door, either because they're daily staples or the important proteins. And because of that, consumer decisions as to where to shop may be driven by a number of items that may be seen as key value items, and then they'll purchase products around that at the store once they're there. We also look at duration and timing, and that I think is important just in terms of obviously something that persists for a long time. The Commission's going to take a view of the cumulative effect, because if we're looking at profitability in investments, it's about the cumulative eating away of profits over a longer period. But also there may be times where, for instance, promotions that are short-lived in terms of differential price, but which can have a big effect on demand in the short run. Well, those will also concern us as well. But generally, we're interested in persistent differences that lack a justification. So to take a context, in the resale context, so this would be your wholesalers and your retailers, and where this is a supplier, so probably a agro-processing plant that's large, or a supplier of branded products, again, that is large. But in this context, really the product is bought and resold, and there's no transformation of the product. In this context, you know, for a retailer, in order to not to lose sales because of the differential, they must be able to match the prices that others will put it on the shelf. So if the difference in price is such that they cannot match the price put on shelf by a larger retailer or wholesaler, well, then there's clearly an impact on their ability to compete, to participate effectively. This is all the more likely in the case where it's an important driver of sales. But some of the established law, even globally from the US, was in relation to salt, and their difference of 10% was deemed sufficient, and salt is a product which is on the shelf with many other products. So the Commission will look at, in fact, whether the resale price can be matched or not. So that depends on what sort of markups are typically put on by retailers and wholesalers to these products. The flip side, of course, is if I do have to match that price, but have to do so at such low profitability or losses, because it's a key value item, then that invokes the other element from the regulations, which is the profitability and investment test. So that's more of a resale context where we're looking at differences in price and the resale price as well. In the intermediate context, so this may affect, for instance, your big suppliers of farming inputs to farmers. The importance from a cost perspective does loom a little larger because there is processing involved. But here, typically, your things like fertilizers, seeds, pesticides are all big cost items for farmers, and would be coming under the sort of purvey of cost importance. On these, obviously, we need to consider the extent of the price difference, how much it impacts on the cost of the farmer, but also then looking at that in the context of the net margin earned at the end of the day. So it might be a 1% difference in your cost, but if there's a 5% margin at the end of the day, that's 20% of your margin gone, and that may affect your investment and the like. So from a price discrimination perspective for intermediate products, we would be looking at that difference in the context. I think then lastly, just to round off again, objective justification, to repeat that firms need to look at their justifications. Volume is not a basis for an objective justification recognized by the Act. So one has to look at what is the reason for the difference in price, and does that difference in price justify to the full extent by the difference in cost? You know, and again, drawing on that appeal court ruling recently, in fact, the decisive factor, once the prima facie case had been made by the Commission, was that although a defence was put up by the firm that they anticipated costs increasing, they could provide no evidence that their costs would increase to the extent they put up prices. So the extent matters, and the appeal court has recognised that. Thank you very much. That's all from myself, and I'll pass back to you, Nimrod, in terms of taking questions.
Great. Thank you very much, James, for that very detailed input and very valuable input, and also Reena for setting the scene. I see that there are already 2 questions on the Q&A. One thing that I forgot to mention, which would be quite useful, is perhaps when people put up the questions on the Q&A, if they can indicate what company or organization they're from or they represent. I think just to engage in a bit of unfair competition on my front as the chair, I wanted to kick off by posing a question of my own, and that's really, obviously a large part of the motivation for these regulations, these guidelines, is one of equity, of increasing participation by firms that have been there've been barriers to entry set up that have prevented them from participating. One thing that I'd be very keen for both James and Reena to comment on is, what is your view on the kind of net positive economic impact of these provisions on the economy? So, for instance, does one anticipate that the greater participation of smaller firms is going to raise the labor intensity of, supply of suppliers? One would also hope that by introducing more competition in the domestic market, that would shift the incentive structure of large producers and possibly even large retailers to expand into export markets. So I think it would be very useful if you could respond. Know what the Constitutional Court ruling that James was referring to, if you could elaborate on that. Odie Stradom has asked, is there anything, are we aware of competition laws in North Africa, specifically the Tunisian law of competition and prices? Does that offer us any guidance? So I think these are mostly directed at you, James, but I think Reena can perhaps also come in on the broader issue of the net economic impact. And then, please keep the questions coming.
Thanks, Nimrod. I think I've already covered the first question. So if the prices are inferior relative to an adjacent market, then we would consider it, because, as I indicated, discrimination can prevent entry into the market. So what we're typically using in our own guidelines is a line of business that one looks at. In terms of the ruling, I'm actually referring more to the Babelehi ruling in terms of price gouging at the appeal court, but it did deal with issues of market power outside of market share analysis, and that's where it did determine that we can look at conduct to infer market power. And the second element is, although it was dealing with excessive pricing, it also ruled on the prima facie case, establishment of a prima facie case, and then the onus shift to determine whether the price is reasonable or not. Now, those same prima facie case provisions exist within the Bypower and price discrimination. So I think that ruling will resonate in terms of how these are treated as well. In terms of Odie's question, I think different jurisdictions have taken different approaches to the issue of buyer power. But what is clear is that I think almost universally this has become a big issue. So in Europe, they've adopted more the approach of regulations. We're using competition law, but even at a national level in Europe, and as Odie points out, in North Africa, there are laws, for instance, in Germany around economic dependency, and a similar approach in terms of establishing buyer power dependency and outside options are always factors that are taken into consideration. But in fact, even the House report on the digital markets in the US has highlighted the need for biopower provisions within the US context as well. And certainly even some of the commentators there have focused on biopower, even so far as labor markets are concerned. So I think there's a universality of approach. It's just what toolkit you may choose to use. Nimrod, I'll let Reena go first on your own question, and then I might add some comments.
Great, yeah. So Nimrod, you were asking about the net positive effects of these provisions. And I think it stems back to the creating an environment that allows greater participation of SMEs for many different outcomes, both economic and social. So you had mentioned the labor implications of this. So if you have more SMEs participating in food value chains, that has a direct labor implication. But we can also look at that from a very sort of localized and regional perspective. So SMEs that are located in particular parts of the country, if they have better access to retail channels or routes to market in those parts of the country where there might not be other economic opportunities, this creates positive spin-offs for that community as a whole and that particular localized area. So there are these much wider benefits, not to mention the more obvious benefits of having greater choice, better quality products when you have a degree of competition, including from fringe players like your SMEs in food processing. Another very important point to note is that, and this James mentioned it is the increasing levels of concentration that we're seeing in agro-processing. So you typically have your multinational food and beverage companies that are increasingly dominating many markets at that level. This also has implications for smaller retail outlets or your independent retailers or your non-chain type of retailers in terms of their ability to access good quality suppliers. So creating a diversified supply base at the food processing level has multiple effects and net positive economic and social impacts, I think. Thanks, James. Over to you.
Thanks, Reena. Yeah, maybe to highlight, I mentioned that we've been doing work on concentration, but for instance, in grain farming in the last 5 years, and this is across all grains, there's been a 30% reduction in the number of farmers, which is quite alarming. Now, one may say that, there are benefits from scale and that's what's happening, but part of the scale benefit is simply you buy inputs at a better price. And that's a sort of benefit that shouldn't be used against smaller scale farming, because farming does offer an opportunity almost to bring people into employment. It should be a mass employment part of the economy and yet isn't. So it does directly go to that element. I mean, to bring about another aspect from the study that we've been looking at how firms transition from small to medium to large. But again, if medium firms become larger firms, they increase the contestability of a market. And there is evidence that some of that is happening, but maybe not to the same extent we would like. But it does start to bring about better, again, in the agricultural value chain as well, better consumer choice. That it's not just about product and a price for a standard product. Consumers do want choice and a variety, and that has enormous value. The quality and price trade-offs that take place. So that's why I think there's a lot of material benefits and no real downside to these sort of provisions.
Sorry, let me start again. I think I was muted. So there's a question that's been posed by an attendee who wishes to be anonymous. And the essence is if customers are given a short period to comment on changes to terms, in this case, what's referred to as a levy to deal with certain urgent risks, is that is that acceptable? would that kind of, I suppose, prevent you know, action under the Competition Act? James, do you want to take that?
Yeah, thanks, Nimrod. I think I did cover this in my dairy example, but you know, in that example, contractually there was a month's notice, and in fact, it is possible to meet with most of your suppliers. One can arrange forums, even for small businesses, and that is in fact what happened in the case of one of the firms. So in fact, our response by saying this is unilateral conduct, unfairly imposed, and you're in violation or contravention of the act if you proceed, did result in a process which was in fact fairer, did engage the suppliers. What I would warn against in terms of that sort of anonymous comment is sham negotiations or sham consultations, which is exactly, well, I've sent an email out and I've given you 3 days and therefore I've consulted. Well, I think no court's going to really look at it in that context. So it is important that there is in fact engagement. But I'd also highlight that almost the two twin evils, let's say, of price discrimination and buyer power have been exposed or exacerbated during the COVID crisis. So when all firms are suffering throughout the economy because of this pandemic, obviously aside from those that maybe have sold more because their products in demand, but all other firms are suffering, we have seen increasingly the desire to transfer costs or risks onto trading partners, be them suppliers or customers, by firms. And that is a demonstration of their power in the market, either as a buyer or as a seller. And the dairy example I gave was exactly that yes, there was some uncertainty as to how dairy products might sell during lockdown level 5, but that didn't warrant a unilateral action just to shield the processes from any harm. So we would look at, for instance, in that context, the distribution of costs between and where the margins are equally affected. But that market circumstance is not unique, you know, to the processor alone. All firms face that, including their suppliers. In terms of just the question of complaints from Paul Kutzer, I've mentioned a number, and we've tried to resolve some of these during the COVID crisis fairly immediately before some conduct was imposed. So rather get firms to retract those sort of unilateral actions. But at this stage, I can't give you the exact numbers. I haven't gone to look at those. But we have got a number of price discrimination complaints, and we're investigating some of these. But again, what we are hoping, I suppose, through this process, as I mentioned, is that, in fact, the guidelines empower small business to engage. So we are aware, for instance, in dairy, after that initial actions that we acted on, that in fact the guidelines have become a basis for some of the negotiations between farmers and processors. And that's what we hope to achieve most of all in that getting compliance and getting firms to move. We have had engagements and positive engagements with some of the large retailers, and we've had some informal feedback from suppliers to those retailers that has said there's been a sea change in their attitude and treatment. So what we would hope most of all is that the guidelines prevent the need for enforcement. Obviously, there will be those circumstances, but it would also be good to get feedback from industry players as well as law firms who represent big players, whether there has been a change in conduct and whether that has had positive effects or not.
Thanks. I see that there's a follow-up question on the dairy matter. Perhaps you can just pick that up directly.
Sorry, Nimrod, I don't see a follow-up question on the dairy.
It's from the same person. so it reads, to the point on volume being a valid reason to justify price discrimination, what does that mean for offering tiered volume-based discounts? Does this mean that using this kind of pricing model, you immediately fall foul, presumably of the regulations, or are there other aspects that could be used to justify this? And then another point about incentivized price discrimination concerned with the commission becomes the relevant factor that an SME or HDI buyer's inability to thrive in the resale market may be due to its inefficiencies.
All right, let me pick up. I'll start with the second one first, because that was a point I'd hoped to cover, but I think I'd missed, is that if you read our guidelines in both contexts, Bypower and price discrimination, what we make clear is that we are looking at the impact of this conduct. There may be many other things happening in the market, but the question is whether this conduct itself has the ability to either impede effective participation, that price difference, or it's unfair. So the mere fact that an SME might be inefficient is irrelevant to that assessment process, completely irrelevant. So it's just whether this contributes. In terms of the point on volume discounts, I mean, the law is quite clear that in justifying a price difference and whether that difference is reasonable, the supplier doesn't have recourse to the volume and even costs that are volume related. So to the extent this may start to impact on volume discounts as a category, it will impact, and those will be under scrutiny. I think the question that comes to the Commission is ultimately, is the difference, if it can't be justified, does it at least pass the threshold test of impeding effective participation? So that's where we have said in the draft guidelines that a small price difference, that even if it's not justified, may still not impede effective participation, and that may be, in a sense, a backdoor for putting in a price difference. But that is something we're going to continually review, because we need to ensure that some initial threshold for screening in order to just manage the casework is not used as a permanent feature that allows persistent discrimination to exist.
Thanks, James. Reena, would you like to come in on any of these questions before we move on to the next question?
Thanks, Nimrod. I think, yeah, I mean, these questions are very specific to the way the Commission is going to approach these cases, so I don't have much to add. I think James has covered that. I think perhaps just a point that came to my mind when the anonymous attendee asked about the levy and giving notice to suppliers, perhaps by email, and giving them some time, a few days, to comment on that. I mean, certainly a lot of our field work that we've done, where we've interviewed small and medium-sized enterprises, we understand that this is a problem where there's not enough proper engagement on the reasons for why certain costs are added. And this is, of course, probably exacerbated by the COVID crisis. But there definitely needs to be a lot more engagement so that there's an understanding of why certain costs are imposed, or at least if there's some negotiated outcome on the sharing of risks and costs, as James has said. So this is certainly something we're seeing on the ground as well, James, as we interview the small players. I'd just like to add that. Thanks, Nimrod.
Okay, thanks for that. Then there's a question from Odie Stradom. I'm not sure if it's really directly about the regulations and the guidelines, but I think it's really about whether one can expect to see large retailers prosecuted for undue price increases. James, if you want to address that, please.
Sure. Yeah, I don't think it's directly related, but I'm happy to answer. I think what's important as we see is that in terms of price gouging and through the COVID crisis, the Commission has had a multi-pronged approach. So it's combined a lot of advocacy efforts along with enforcement. And in fact, we'll be releasing soon an impact study on some of our enforcement during this period. But part of that has involved substantial direct contact with executives at the large retail chains in order to keep prices in check and respond. So that happened prior to the initial gouging complaints and the first wave of infections and lockdown. And it has also been used more recently in terms of the ginger garlic issue. And where large retailers control corporate stores, they're more able to impose that and show restraint. In terms of general food inflation, it is something we're looking at. And we've also signaled through those reports that this may be an area for a future market inquiry as well. I think there's many issues that are emerging that we're concerned about in certainly the food value chain. Now, Bypower and price discrimination may feature within that, but other practices such as constant markups that don't change when cost prices change, all add to, I think, food inflation in the market. And there may be existing tools that can be used, but it can also be that an inquiry is a preferable method to address some of this. There are also parts of this chain we don't understand as well, I think, such as the municipal markets for fresh produce, where we're getting some interesting outcomes and which we need to look at. I mean, in terms of the concern that this will effectively fix the cost of inputs and the price payable by consumers, that's not a realistic concern in our view. I think, there has been a fair bit of sort of alarmist and extreme views taken that if enforced to the extreme, this could happen. That's not, it's very much a look at justifiable differences. So as indicated in terms of, let's say, resale products from suppliers and buyer power, obviously at the retail level, differences in branding, quality exist across most food items, barring, say, fresh bread and fresh produce or milk, where there are more standard features to the quality. But their differences may be justified by some of that. It's just where there is no objective justification that retailers need to look how they treat. And that may just be more that they mind what they pay for the product rather than what they resell it at. So I think, again, the elimination of volume discounts is not going to mean that the sky falls on our head. I think what it will mean, in fact, is that smaller firms get an opportunity to compete more on the merits. And that may, in fact, result in a lot more deconcentration of these downstream markets and long-term dynamic benefits that may not be immediately apparent in the short run.
Look, I think most of these questions are flying thick and fast at you, James. So instead of trying to summarize them, why don't you just go ahead and answer them? And Reena, you might want to come in as well.
Thanks, Nimrod. I'm still needing to read some of these questions. I think the first from Dale Adams is around price discrimination provisions and the franchisee-franchisor relationship. Look, I think that relationship has a special place within competition law in any event, and already is treated somewhat differently in the recognition that some of these requirements from a franchisor may be, for instance, required in order to run a successful franchisee business. So it's unlikely that we're going to, be highly active in that space unless there's cause for concern that arises. In terms of the treatment, and from Paul Kutzer, the trend, and they are coming thick and fast. I'm assuming this is in relation to price discrimination because it's looking at the profitability on investment. I think, again, you know, this is a likelihood test. So if there's a persistent difference over time, then the question is whether that difference in price and persistence of price itself is likely to result in sufficient impact on profitability such that investment is likely harmed. And so any sort of looking at short-term fluctuations may not be the primary focus of an inquiry, and it may be far more about whether this persistence is likely to hinder investment and profitability over a longer period of time. I think where short-term impacts can come in, and I'd use an example, let's say from agriculture, that maybe a difference in price for fertilizer at the point that it's required may be short-term in duration, but in fact long-term in terms of its effect. And therefore, some short-term pricing can have knock-on effects. If that's your seed for planting and it's planting in November, and that's when you face the price difference, well, you know, that determines your annual income as a farmer. So I think those are where short-term can come in. Similarly, in areas like construction, where, you know, your ability to compete in a tender may be impacted by the pricing that you can receive for certain inputs, important inputs.
Thanks. And then, I mean, I think this question that interests the demarcation of designated sectors. So I think this is a very interesting example. So obviously some retailers would have pharmacies in-store pharmacies. So, you know, if the products in question or the suppliers in question are supplying products to that pharmacy, you know, branch of the business, is that part of the retail sector? You know, I think that's actually a very interesting question.
Maybe I'll quickly answer that. I mean, the schedule on SME qualification really uses your standard industrial classification, and if you look at that schedule, that's in fact what it says in terms of the legislation. So the standard industrial classification has multiple layers below that. So one can just use the SIC codes as they're known in order to look at level 2, level 3, level 4 and see where these products lie. But on my best guess, I would imagine that pharmacies will sit within the retail context, but the difference between community, social and personal and retail in terms of turnover threshold is in fact minimal at 70 versus 80 million. There is a uniformity across the entire economy now in terms of full-time equivalent paid employees, where it's you know, less than 10 or 0 to 10 is micro, small is 11 to 50, and medium is 51 to 250. So there's a uniformity and shouldn't cause concern. But I'm sure you can go online, Heather, and get the SIC codes to look at that. And then there's just a question around comparing the prices of products to other SMEs or firms other than SMEs. And the primary comparison is to firms not in the same class. So it would be firms that are large businesses. And typically in this context, you know, in something like price discrimination, it is the larger firms that historically had received a better price. So that would be your primary point of comparison. Thanks.
I think that there's been quite a number of questions that have been posed. I think that you know, what I would like to do maybe is just take one final round of questions. I would give preference to people who haven't posed questions already. Before we take that final round, Reena, is there anything you would like to add at this point?
Yeah, I think it's also just building on that last question on what a comparison would involve, and it goes back to one of the last points I made around back to supply development programs. If the primary comparison is outside the designated class, therefore with terms and conditions being offered to larger players, are there still possibilities of comparing SMEs that fall within the supply development program to SMEs that are outside the supply development program? Would that be one possibility that the Commission might look at in terms of comparison? And if so, what does that do to the incentives for the supermarkets to enter into supply development programs, if that might, in the future be used against them when looking at SMEs outside? So this is just something that I've been thinking about as we embark on this master plan process. Sorry, that's just me adding another question onto your list, James.
Okay, so look, I think then this is going to be the last question. The gist of it is, in the time that it may take the Commission to investigate a complaint, there's a risk that an SME may go out of business. What is the Commission's response to that?
All right, let me pick up Reena's question first, and then I'll come to this one. I mean, we have under the, I think, the frequently asked questions, put an answer around supply development. And what we had indicated there is that if you're trying to treat a particular class of suppliers more favorably to develop them, then that program itself is unlikely to fall within the ambit of a contravention, and you also presumably wouldn't have complaints from those firms against you if it's a retailer context or a process context. I think the comparison is primarily against outside of the class. What we cannot do is, and it was argued at the process of developing guidelines and regulations, that the mere existence of a supply development program should give you a free pass on this provision. And that we cannot do because, for one, we cannot take away the rights of a small firm that's not part of that to lay a complaint and to refer itself, even if the Commission chose to avoid it. But also, what we can see is that there's supply development of a limited nature in one particular area, but exploitation elsewhere, and we can't turn a blind eye to that either. So certainly, we don't expect that those will fall foul of the provisions, and it shouldn't create risk elsewhere, but it is still a requirement that you treat all your suppliers who may be small or historically disadvantaged fairly in terms of the Bypower provisions. It's not a free pass. In terms of what the Commission can do, so, I mean, here there's a multi-pronged approach, and I do think putting out clearer guidelines helps in terms of that initial engagement. As I indicated, we have had feedback that this is starting to happen. Of course, small firms need to be empowered. They need to be aware of what their rights are, and they need to be able to lodge a complaint. I think the second response is what the guidelines are also trying to do is to demonstrate that this test is not overly difficult in terms of evidence and demonstration, is to try and keep it simple. So in terms of even things like Bypower, we're excluding overly complex tests on costs, etc., by focusing on the most severe abuses and the most obvious abuses. So I do think in this context, we should be able to speed up the process. We've also, internally developed more investigative notes and plans and processes in order to do exactly that. The last area is that the Commission is to be resourced, additionally to in fact act on these amendments. And that was always part of the plan, that in fact additional resources to enable the Commission to add additional complaints such as these against small businesses for Bypower and price discrimination. That is on top of our normal workload. So those resources need to be there in order to enable the Commission. I mean, I'd highlight another problem, which obviously we're aware of, is that in terms of price discrimination or even Bypower, small firms may not be aware of what others are being charged, or in fact, the prices that they're receiving for their goods. So in fact, that is a knowledge gap which creates big risks in the economy. And that means that we are also going to self-initiate as a Commission in various cases where we believe there is discrimination, and we've already done this. in order, because the small firms or historically disadvantaged firms may not know the difference in treatment. In fact, the Mr. Foot complaint, the SASL nationwide polls, arose because he inadvertently received a fax meant for some other customer, and that's how he gained the knowledge. So these are big risks for us, and this is where I think, what is the important part of this whole process is also creating a knowledge and advocacy out there, and that's why I think webinars like this are important, that business organizations need to go to their members and look at whether they are aware of these guidelines and can exercise these guidelines effectively.
Great. Okay, look, thanks. I think I think we've covered a tremendous amount of ground in this session. So I'd really like to extend my thanks to yourself, James, and Reena. I think, Reena, by way of wrap up, there have been a couple of questions about where people can access a recording of the webinar. My understanding is that it'll be posted on the CRED website, which is www.competition.org.za. I think that it's also worth visiting that website to draw on, I think, the wealth of research that's been generated by CRED around market structure, issues of competition, barriers to entry and so forth, and industrial development in a range of industries, but a lot of that work has been done in the kind of around the food and retail nexus. So with that, thanks again to the presenters. Let me also thank the colleagues who set up the meeting, who were involved in the logistics, if you like, behind the scenes, colleagues from my own office, as well as from the Commission and from CRED. And I think with that, we can bring this webinar to an end. Thanks again.
Thanks very much.